Okay, we are live. I'm just going to make sure that it says we're live on YouTube. Okay, we are live. I'm going to put a link on the Facebook group. All right. So, John and I wanted to do this little review of this document that we were given just today. And so what this is Senate Bill number 1, which was released by Senator Susan Glick, from LaGrange. Her and Roderick Bray, the pro tempore, had a press conference this afternoon discussing what kind of legislation they were going to be doing in the upcoming special session. They're starting in the Senate as opposed to starting in the House. So we just like to go through this and share our thoughts and specifically our concerns, as we think it's pretty problematic.
Yeah, so I think, just talking about what happened today, it's important to note that those who are introducing this bill, those who spoke on it, are Republicans who were elected on a pro-life platform. So these are people who have been, whose political careers are built on the votes of people who believe they're there to help end abortion. So I think that's important to note starting out. And
Yeah.
I think maybe laying some scriptural foundation before we go in sound good to you? So I was just looking here, just a few things from the Word of God. In Deuteronomy 16:20, God says, "Justice and only justice you shall follow, that you may live and inherit the land that the Lord your God is giving you." So any laws that we pass have to pursue justice and only justice, nothing else. And Micah 6:8, "He has told you, O man, what is good, and what does the Lord require of you, but to do justice and to love kindness and to walk humbly with your God." And then finally, Exodus 8:11, "Because the sentence against an evil deed is not executed speedily, the heart of the children of man is fully set to do evil." So I just think keeping those in mind as we go into this is really important, that God commands us to seek justice and only justice. And he says that the heart of man, the heart of children of man, is fully set to do evil because the sentence against an evil deed is not executed speedily.
Yeah. So those are foundations. Those are presuppositions. If you're going into this and you're disagreeing with our conclusions, it's because we are starting with a worldview which says that God has spoken and that God has ordained the government, the state, to provide and to protect and to punish evildoers, Romans 13. So if you don't have that foundation, what we're saying might not make a lot of sense. But what we're saying is, without Christianity and the God of the Bible, you can't make sense of culture in the first place. And so we're not taking this idealist position, thinking somehow we're going to make this utopia. No, we're simply understanding that God has ordained the civil magistrate to punish evildoers, and we're advocating that the only standard we have to punish evildoers is the standard given in God's word. And so what we're seeing with Senate Bill 1 is the obstacle of the Roe versus Wade decision is gone, what they would consider an obstacle. And so in a sense, they are given a blank slate, right? The Republican supermajority can choose whatever they would like. There's no judicial supremacy bogging them down saying we're not going to give you state funding or federal funding if you don't act a certain way. And so they're starting here with a blank slate, and this is what they're choosing to introduce. And so we would have liked for them to introduce legislation which says, Exodus 20:13, "You shall not murder." That's the 6th commandment. We believe that second table of the law should be legislated. We want to legislate the Christian morality. But these senators have another idea. There's a different morality they want to legislate, and so we're going to look at that. I was going to share my screen and go through the bill, but I have to restart Chrome to do that, and I think that would cut it out. So I have it here. If you just Google Senate Bill 1, Indiana House, it should come up.
And it's the special session of the Senate.
Right.
It's not from the regular 2022 session.
Yes, that's why it's just number one.
So we can provide a link in the comments after.
Yeah. And so first, what I'm noticing going through this is it has a lot of citations affected. And it has all of these different things. And towards the end, it says repeals obsolete provisions and makes conforming amendments. So the first reason for that is because during Roe, the legislators had attempted to regulate abortion in so many different ways. The abortion code is super long and it affected so many things. And so that's why you're going to see in this 15-page document, there's a lot of interaction with different code, whether it's with the rape code, how it defines consent, how it defines abortion-inducing drugs. All these different things are going to be interacting with the current code, getting rid of a lot of it, but trying to still interact with that pre-existing framework, which isn't what we wanted to see. What we wanted to see, and the brilliance of the Life Bill, is that you simply take the fact that life begins at conception, and the Constitution already recognizes that, and you build off that. You don't build off the pre-existing. And so the first page of the document here, it defines what abortion is. And it defines it as the termination of a human pregnancy with the intention other than to, and then it adds a clause, and that clause is terminated pregnancy where the fetus suffers from an irremediable, in reference to medicine, medical condition that is incompatible with sustained life outside of the womb, regardless of when the child is born. And so this is the introduction of the first exception, and this is going to be a common theme in this bill, is exceptions. So it's defining here what it means by kind of life of the mother. Then it goes on, it's going to define surgical procedures and abortion-inducing drugs and stuff, and it's going to define pregnancy, it's going to define rape and incest, it's going to define sexual misconduct, reasonable medical judgment, these different things. Is there anything you comment about these definitions?
Yeah, so just back on that first one there, where the definition of abortion. So the first thing they do, the law currently as it stands defines abortion as the termination of human pregnancy with an intention other than to, one, produce a live birth, or two, remove a dead fetus. So that's the commonly accepted definition of abortion, and has been for the last 49 years. But what this is doing is adding an additional exception to what abortion means, and says that an abortion does not mean killing the preborn child if that child has a medical condition that would make it so that they would not be able to live a normal, healthy life outside the womb.
Yeah, and when I think of this language, this could be easily applied to euthanasia, right? Their medical condition is incompatible with sustained life outside of the womb. What about their medical condition is incompatible with sustained life outside of the nursing home, outside of the ventilator, right? So right off the bat, this is the language of sort of eugenics almost.
Yep. Yeah, and so then the next definition is the definition of what a preborn or unborn child is. The law currently says that a fetus is an unborn child, irrespective of gestational age or the duration of the pregnancy. This bill would redefine that so that an unborn child or a fetus is only after implantation in the uterus. And I think that's an important point, is it specifically says in the uterus. So they do not consider it, the Indiana Republican leadership of the Senate does not consider a child to be a child unless and until implantation in the uterus.
Yeah. And this is,
So
this is extremely problematic. Maybe some of you have seen these quad folds. They have citations. Here's a citation from an embryology textbook. Human development begins at fertilization. And so in the press release, they were talking about consulting scientists and doctors and OBGYNs and all these things. They're saying they're going to do this. And then they're literally stating a counterfactual claim that science rebuts. I was just at Right to Life's Life Defender class, and we were going through medical embryology. And what we learn is that life begins at conception. That's extremely basic, and that's something we've been touting for a long time. But this is a rebuttal to that, saying when it's implanted, right, or that when it the uterus is when it's implanted in the uterus, and so right off the bat, that is a problem. But what we're going to see later, and especially during the press release, they mentioned this a lot. There's a reason for that, and that reason is they didn't want to trigger the IVF in vitro fertilization folks. They didn't want to trigger the sacred god of Plan B and the after morning pill, because the truth of the matter is these pills, if it stops it from implanting, by definition, if it's already fertilized, that's a life, and that's abortifacient in nature. And so it has to redefine an abortion, and it has to redefine life.
yeah. And then in conjunction with that redefinition of what a fetus is, they redefine pregnancy to also mean the female reproductive condition of having a living fetus implanted in her uterus. So right off the bat, an ectopic pregnancy, according to the Indiana GOP, doesn't exist. It's not really a pregnancy. That's not a child. That's not a human.
Very good point. That's an excellent point. I want everyone to make note of. Under this definition, right, pregnancy or pregnant, for purposes of Indiana constant whatever, means the female reproductive condition of having a living fetus implanted in her uterus. So for all those people that have had ectopic pregnancies, you were not pregnant according to this document. That is something ontologically different. You were in a different state. You were not in a pregnant state. So here's just another false scientific claim being promulgated by the state senate just for the purposes of what we'll see later, which is vice.
Yeah. And the next definition is just on rape or incest. It's nothing. The section itself is fine. It's just it shouldn't be here because the abortion code shouldn't be here.
Right. Yeah. And so there is the internal critique side of, even within the framework of having exceptions, this is contradictory. And then there's the external biblical worldview. Okay, you shouldn't say when children can die in the first place.
Yep.
And from that perspective, if I were a child sex trafficker, this is exactly the kind of language that I would want in here. This sexual misconduct with a minor, child seduction, child molesting. This is page 2, starting at line 29-ish. I would love these exceptions. And what we'll see moving forward is, in these exceptions, there is no requirement for a police report to be filed. And all that is required is giving an affidavit to the abortion provider themselves, and that affidavit is specifically mentioned to be confidential.
Mm-hmm.
And so if I was trying to human traffic people to get abortions, to discard the evidence, that life, from a rape or from trafficking, this is exactly the sort of language that I would want. And so another huge flaw.
Yep, that's an excellent point. So the next definition is reasonable medical judgment. And this is referring to when a physician can decide that, in his judgment, an abortion is quote unquote necessary. And so it's saying the reasonable medical judgment for purposes of Indiana Code 16-34 means a medical judgment based upon the facts known to the physician at the time that would be made by a reasonably prudent physician who is knowledgeable about the treatment possibilities concerning the medical conditions involved. Now, I think a couple of things to point out here is, how do they define reasonably prudent? Because any physician who's taken an oath to first do no harm is what I would consider a reasonably prudent physician. And that was going to be their first goal, is not doing any harm. But then secondly, that knowledgeable about the treatment possibilities concerning the medical conditions involved. And as we've seen, even from, I don't remember his name at the moment, but the former U.S. Attorney, or not attorney,
Surgeon General.
Surgeon General, thank you.
Yep.
That in his years of practice, he had never seen a case where an abortion was necessary to save the life of the mother. You know, in every case, you let that pregnancy continue as long as physically possible, and then if necessary, early delivery or a C-section. But there's no case in which you must kill the child in order to save the life of the mother. And so this reasonable medical judgment basically gives that doctor complete leeway to kill a child for any reason he deems necessary.
Yeah, and they're going to say over and over, and it does mention something to the effect earlier of, like immediately endangering the woman. But when you have precedent from different cases in Supreme Court past history, it's not just Roe, it's all these other cases, and many of them, there's a redefinition of life and health of the mother, to where we even see her physical or her mental health. And I don't think this is exactly where this is going, but the fact that it's so vague opens that up to questions, because when you do treat abortion as a highly regulated medical practice, there's questions that could come. And so this really, what we're trying to do in this video is show, with how horrible this language is, it opens Pandora's box for different issues. Moving on, I'm looking at page 4, talks about different requirements for existing and future abortion clinics, and establishing procedures regarding the issuance of licenses to existing and future abortion clinics. So even in the text right there, it is assuming licensure of future abortion clinics. So again, there is some stuff that it sounds like it might be trying to tacitly push the abortions back into the hospitals, but it's still kind of assuming that abortion is going to be an ongoing thing in our state. Again, it's just regulating it, and in regulating it, you are assuming its pre-existence.
Right. So basically, the only, as we'll see as we go into this, the only thing that will be prohibited in clinics is surgical abortions. So the reason this is here is because they will still allow for existing and future abortion clinics to do chemical abortions.
Yeah. And as we know, chemical abortions are the large percentage of abortions, which is just a horrible thing, because the accessibility goes up, and etc. As we move on, is just tons of code is just being striked out, which is necessary for it to be compatible. Page 7. Towards the end of page 7, it starts to get interesting. Line 36. Abortion is unlawful unless all of the following apply. 1, if the abortion is a surgical abortion, the abortion is performed by a physician licensed under, and then it references some code. 2, if the abortion is a surgical abortion, the abortion is performed in a hospital licensed and under the code, an ambulatory outpatient surgical center as defined in, and then it gives the code, that is owned by a hospital licensed under it, unless it is necessary to perform the abortion in another location due to a what they call a medical emergency. And hopefully that wouldn't be some sort of mental thing. I don't think it would, but again, the question's there. If the abortion is induced by an abortion-inducing drug, a physician must dispense the abortion-inducing drug in person and have the pregnant woman consume the drug in the presence of a physician. And it says, the physician must examine the pregnant woman She has to give them instructions. Still, she has to tell them some evidence suggests that the effects of mifepristone may be avoided, ceased, or even reversed if by the second pill misoprostol has not been taken. All of this stuff is just rewording what's already in there. This is why the abortionist Mira Shaw from New York flies to Chicago and then drives to South Bend every couple of weeks, because there's already in the code now, there has to be a physician there just to dispense the pills. And so, again, we're still just regulating it, and we're still just telling people under what conditions, and we're still telling them, well, this pill might be a little dangerous and it can be reversed, but you can still go through with it. And so, and then it goes on to just give some more requirements, signed copies of the patient agreement form, the manufacturer, etc. The woman submitting to the abortion has filed her consent with the physician, necessary to preserve the life, etc. Talks about legal guardianship, reasonable medical judgment, and those sorts of things, rape, incest, those sorts of things as well.
Yeah, so a couple of things I'd like to point out in this section. Even that first line you read, line 36 of page 7, abortion is unlawful unless all the following apply. So one of the things that Senator Glick talked about today was this whole idea of criminalizing women, which is a misnomer. That would be what's commonly termed as sexist, to criminalize women. But you do criminalize crime. You criminalize the act, not the person or the gender. Just like we don't criminalize men, we criminalize rape. We don't criminalize women, we criminalize abortion. And the law as it currently stands actually says, the section being modified here, actually says abortion shall be in all instances be a criminal act. And then of course goes into these exceptions. But she doesn't like that word criminal act, as she pointed out in her press conference. And so she's changing it to abortion is unlawful unless all of the following apply. So just that watering down, it's not a criminal act. This woman isn't a criminal for killing her child. It's just unlawful.
Yeah.
And then I think too, just some concerning things that line 26 on page 8, the woman submitting to the abortion has filed her consent with her physician. However, if in the judgment of the physician the abortion is necessary to preserve the life of the woman, her consent is not required. So if the doctor determines the mother is not going to survive this pregnancy, he can kill her child without her consent, without her husband's consent, without grandparents' consent. Not that it's okay to kill with consent, but just the recognizing the depths of the depravity here, that the doctor can decide, I'm going to kill your child. It's for your own good. I don't need your permission.
Yeah.
Then line 34, it seems to extend beyond just the life of the mother to permanent disability, because it says that an abortion is necessary to prevent a substantial permanent impairment of the life of the pregnant woman.
Yeah, it's an equivocation, because at the start, I mean, when the press conference, when she talked, I thought she was just referring to the life of the mother, i.e., if you don't take this baby out, abortion, air quotes, she's going to die. And now it's the impairment of the life. It's a blatant equivocation going on.
Mm-hmm.
So that is another extremely problematic point.
And then you already mentioned this one, but just it's the next point in here. The other exception is the pregnancy was the result of a rape or incest, and the pregnant woman provides the physician with an affidavit signed under penalties of perjury attesting to the rape or incest. However, the next line says the affidavit provided under this clause is confidential.
Yeah.
Which means there's no need to report a crime. Yes, there's this
penalty of
statement
perjury.
of signed under penalties of perjury, but nobody ever needs to see that statement to know whether or not she lied.
Yeah, and it's confidential. And what is the abortionist getting $700 for the abortion going to say, actually, I don't think this affidavit is genuine? Are they going to say, no, you're wrong, I think you need to be punished under the penalty of perjury?
Yeah.
I don't imagine. I'm not expecting that level of moral decency from a person who makes a living killing babies, or worse, volunteers their time and does it for cheap, like Allison Case. So I'm not expecting that at all.
Yeah.
Yeah.
And this also, just going back to one of the previous point on how it goes from life of the mother to impairment of the life of the mother, it does leave in here that a person may not knowingly or intentionally perform a dismemberment abortion unless reasonable medical judgment dictates that performing the dismemberment abortion is necessary, one, to prevent any serious health risk to the mother, or two, to save the mother's life. That health risk issue leaves wide open all sorts of possibilities. You know, she's going to have severe depression the rest of her life. She's going to have, some rupturing of the uterus or whatever. Anything
Yeah.
they determine as a serious health risk, they can now do a surgical dismemberment abortion. And as far as I can tell from reading through this, that's up to birth. There's not even a limit on
Yeah.
that.
Page 9, starting at number 27. I think it's going to keep intact the 20 weeks post-fertilization. An abortion may be performed after the earlier of the time a fetus is viable or the time the post-fertilization age of the fetus is at least 20 weeks. And so even though that's still there, and you might say,
Only if.
right, and so you might say that, but we just had Roe versus Wade and Casey overturned.
Mhm.
Casey was the reason for viability. You know, in Roe, it was
Yeah.
this gestational framework. Casey threw that out. Planned Parenthood versus Casey said, no, we're going to do it in terms of viability. The states cannot regulate pre-viability in what they called undue burden. It can't. It can't put a big burden on the woman to do it beforehand. There's a lot of case law here. So this is still affirming Planned Parenthood versus Casey. This
Well,
is, in a sense, it's still upholding that viability model, that
but
archaic model.
that only if they're actually, it's not even necessarily Planned Parenthood model. Although, the reference to viability in 20 weeks is, but it's specifically saying that as long as there is a second physician,
Mm,
a second physician has to be present,
yeah.
then the abortion may be performed after 20 weeks for viability.
Yeah,
So,
that's
and
scary.
that's actually existing law. Right now, under our existing law, there are exceptions that allow for an abortion after 20 weeks as long as there's a second doctor present.
Mm,
And that is continued here. So,
yeah.
any of these legal abortions in here will be allowed at any time up to birth as long as there are two doctors present.
Yeah. And that the fact that they're just leaving all of this stuff alone, I mean, there's a lot of text here that is just, it's not bold, it's not striked out, it's just, oh, this is the pre-existing stuff. Um, that's just very sad because because everything is just corrupted under that Roe model, and they're just
Yeah.
sustaining it and keeping a lot of it.
On page 10, they're just adding that a doctor providing abortion-inducing drugs must have admitting physician or admitting privileges, or
Mm,
have a written agreement with a physician who has admitting privileges in a
yeah.
hospital in the county or a neighboring county.
Yeah, this is why there's no abortion clinic in Fort Wayne. There was from 1978 onward until somewhat recently, when this went out and no more of the hospitals or physicians did that. In a place like Marion County, it's not a problem. When, Methodist Hospital, Eskenazi Hospital, Riley Children's Hospital themselves are performing abortions, it's not going to be a problem. And when there's all this language that support the hospitals themselves performing the abortions, who's to say they're not going to give permission to other places to do them? So
Yep.
again, this is just garbage.
Then there's just a bunch of just modifying things to include or reference the new language.
Yep.
It looks like.
Yep. And then page 13, we get some new stuff. It is a defense to any crime involving the death or of injury to a fetus that the defendant was a pregnant woman who committed the unlawful act with the intent to terminate her pregnancy. Except as provided in subsection C, it is a defense to any crime involving the death or injury to a fetus that the mother of the fetus requested that the defendant terminate her pregnancy and that the death or injury to the fetus was the result of the defendant's termination or attempted termination of her pregnancy. And then subsection C, it's not a defense to feticide or performing an unlawful abortion, and it defines it. So that's a lot of language just to distill that for us.
So what I see in here is it's a defense to a crime that you intended to commit it. If it was an accident, that's not a defense. But if you intended to commit the crime, that's in your defense, is essentially what that's saying.
Yep. This is just really unlawful. It feels like unlawful.
So
this is the exact opposite role of what legislators and what laws are supposed to do.
Yeah. And this is just going back to that whole thing of they do not believe that the preborn child is fully human and therefore does not have the same right to life as a born person has. And that's actually, I mean, it's even in here. We didn't cover that section, but the existing law, and it's in this document, talks about if the abortion fails and the baby is born alive, they must immediately give it a birth certificate and perform life-saving measures. So they know this is a child. They absolutely know this is a child. They're just trying to redefine it away. And they're trying to say that a woman is never guilty for killing her own child as long as she intended to kill the child.
Yeah.
Which is totally just insulting to a woman's intelligence, to a woman's conscience, and insulting to God's law.
Absolutely. Absolutely. And what's worse, it tries to do the same thing with the actual physician. You want to talk about being guilty? I understand there's some emotional situations where you see women in those clinics and they're crying, and I think that's a small portion of them, but I have seen that. You want to talk about real guilt? It's that abortionist who drives 3 hours to go there to do their rounds, start off in Bloomington, then they'll come up to Indy. They are guilty out of anyone. And as we see here, if they do an illegal abortion, which they'll still be doing legal ones, but that's just a slightly condensed definition of what's legal, they're going to lose their medical license. They can go to another state. No problem. It's horrible. So just looking down here, there's a person who in good faith provides medical treatment to a pregnant woman that results in the accidental or unintentional termination of the pregnancy. Again, goes into licensure of the physician. And then I'm looking here on page 14. Just some more definitions.
That last section there, it looks like, so right now, basically, it prohibits using fetal tissue from aborted babies. It has to be properly disposed of.
And read line 27, the last couple words, page 14, line 27. I'll start 26. A person who violates this subsection commits the unlawful collection of fetal tissue listen to this, a level 5 felony. So if you collect the tissue in an unlawful way, and that unlawful way could be altering the timing, line 24, that's a level 5 felony. If you if you kill the baby though in the first place, you'll get your license removed. And if you're a woman taking those pills, you'll have nothing happen to you.
Yeah. So there is some reference back if you go back on page 11, sections starting on line 14. They do say, except as provided in subsections B and C, a person who knowingly or intentionally performs an abortion prohibited by section 1B or section 1C of this chapter commits a level 5 felony. But then there's some exceptions. So a physician who performs an abortion intentionally or knowingly in violation of section 1A5 or 4 of this chapter commits only a class A misdemeanor. A person who knowingly or intentionally performs an abortion in violation of section 1.1 of this chapter commits merely a class A infraction. A person upon whom a partial birth abortion is performed may not be prosecuted for violating or conspiring to violate. So she can't even be prosecuted for conspiring to violate, even if she requests a partial birth abortion. She can't be prosecuted for conspiring to violate section 1B of this chapter. Yeah, it's just
Yeah.
yeah.
And I mean, even the sort of midway Republicans, not very staunch, probably not Christians, they would say partial birth abortion is horrible. And there have been so many fundraising campaigns against partial birth abortion, and I think that's a big, it's kind of an issue because it's kind of distracting us when, you know, that doesn't happen, at least not in Indiana. But now we're seeing, even in that most horrible case that surely these moderates could grant needs to be illegal, it's still not the same level and stature of other things, which clearly, in terms of what this text says, are at that level. So it's just inconsistent all around, and it's just really a shame that this is what we got. We're praying, and I don't have the citation pulled up. Brian sent me something. Speaker Todd Houston, it doesn't sound like he's super happy with this bill either, from what I am hearing. So we're praying that the House is going to be able to amend this in a way that's going to be much better. Now, ultimately, we want to see equal protection at conception. Okay, treat the preborn, but I don't think we're going to see that. So from that perspective, what kind of amendments should they make? The winsome, pragmatic legislator, what kind of amendments should they make to push it, make it a little bit better? Because from what I see with how bad this is, just about anything is going to improve it. I mean, granted, this is not a heartbeat bill, but in terms of a bill that doesn't discriminate off of age, which, by the way, this technically is that sort of bill where you're pushing back, okay, 15 weeks, 6 weeks, that is that bill. Although it's a very tiny frame where you can still do Plan B, it still is that kind of bill where it's pushing it from conception to implantation. Anyways, rambling there, but give us some thoughts on that.
Yeah, I mean, the most obvious one I would say is get rid of that exception on the definition of abortion where terminating the pregnancy because the baby suffers from a medical condition, strike that. Abortion is the termination of a pregnancy with an intention other than to produce a live birth or remove a dead fetus. Should be, that's an obvious one. The redefinition of the fetus or the redefinition of pregnancy, both of those are obvious. Indiana law already says life begins when a human ovum is fertilized by a human sperm. Already says that. And yet this flies in the face of that statement in Indiana law. So an obvious thing to do is strike her redefinitions.
Yeah. I'm just going to say these redefinitions are going to cause, if this is what we get, are going to cause years and years of trouble, because we are going to be inserting unscientific facts that even the embryology textbooks admit are just wrong.
Yep.
We have issues here of literally what is a pregnancy. It gets that wrong. It gets when life begins wrong, or when protectable life gets wrong. Screwy, equivocal definitions of the life of the mother and the impairment of the life of the mother. Just going over a few things. There's issues with how it defines who can perform abortions, what kind. There's unequal weights and measures as it pertains to chemical versus surgical abortions. Just horrible, horrible things. This is really a messy bill, even from a legal standpoint. It is, and this is just as a person that's just trying to understand this. It's not simple, and it's a framework that's not even consistent within itself. Now, if let's say we were in like a liberal state and they were trying to codify what they understand the protections to be under Roe, they could do it in a way that was internally consistent, although their presuppositions are wrong. This is in a way that it's internally inconsistent and the presuppositions are wrong, so
Hmm.
it's contradictory in and of itself. So yeah, this is horrible. Susan Glick, if you're hearing this, what you authored here, I know you're an attorney, what you authored here is damning to these preborn children.
Yep.
And look at this. These are the children that are not protected. By the way, you don't know if this child was conceived in rape or not, or in incest. You can't tell the difference because it's
Yep.
the same biology. And so when you're predicating the life of the child based off its implantation, okay, a child conceived in rape versus a child not conceived in rape doesn't implant differently. So even your own predication of what is fetal life isn't going to work under your definition of rape or incest. She mentioned something along the lines of the pro-life movement has always supported these sort of exceptions. That's just nonsense. Maybe the midway sort of kind of not Christian, but just the cultural aspect. But that's not what we're fighting for. We're fighting for justice.
Yep. Yeah, and in that light, I think of Isaiah 1:15 to 17, when God's talking to the children of Israel. He says, "When you spread out your hands," and that's referring to prayer, "I will hide my eyes from you. Even though you make many prayers, I will not listen. Your hands are full of blood. Wash yourselves, make yourselves clean. Remove the evil of your deeds from before my eyes. Cease to do evil, learn to do good. Seek justice, correct oppression. Bring justice to the fatherless, plead the widow's cause." And so that's our call to our senators, to our representatives, to our governor. Your hands are full of blood if you in any way push a bill like this, if you sign a bill like this. Um, you need to repent. We call you to come to repentance in Christ and turn from your evil ways, because that, I mean, passing legislation like this, you are just as guilty as the abortionist who does the act. And you have blood on your hands. And God says he will not listen to your prayers.
Yeah, that's the truth. Those are the words of Almighty God. And if you want to choose to reject them, I'm not going to be able to stop you. But we have to warn you, there is a coming judgment. And as you know, people who have more authority have more responsibility. And
Mhm.
as people who are in the state house making these laws, like this little piece of code, these 7 words, whatever, this is going to impact our state for a long time to come. When you're, when we had the abortionists in Fort Wayne before my time, when they added that little section admitting privileges, and then when that went to the state level, that wiped him out. That you couldn't do him anymore in Fort Wayne. Um, just a little bit of code in the wrong way, you're playing with the lives of children here, just on the basis of that little legal phrase. So be careful. That's what we're going to say. Not because we're threatening you, but because the God of heaven and earth loves these little children in the womb, these little ones who you are failing to protect.
Yep.
With that, that is our little overview of Senate Bill 1 of the special legislative session. Special session, that's the SS. On the 25th, it's going to start. They're going to have testimony, I believe, on the 25th and the 26th in the Senate. I got a schedule. Hopefully we can post that. It'll be going around soon enough. Please be there if you can. We need Christians to show up. We do. So, yeah. All right. Well, I'm going to end the broadcast, and we'll see you guys on the other side.
All right. Talk to you later.